Hello and welcome to my channel Happy Hours. In my last video, I discussed about the powers and functions of a governor, ordinance making power of president and governor, discretionary power of governor, fate of bill reserved by governor for the consideration of president and the state legislature. Today, I am going to discuss about the judiciary, Supreme Court and the High Courts, appointment, qualification and removal of judges, and jurisdiction of Supreme Court. So what are we waiting for? Let's jump into the first topic, which is judiciary. It is single and integrated. At the apex, we have the Supreme Court. In the middle, it's the High Court, and then the subordinate courts. The subordinate courts has two parts. First is district, and the second one is session. The district court is for the civil cases, and the session court is for the criminal cases. Now let's jump to the next topic, which is Supreme Court. It is the apex court of the country. Seat of the Supreme Court is located in Delhi, and it can also sit in such other place or places as the Chief Justice of India may be, with the approval of President, from time to time decide, and it is mentioned in article number 130. Now let us know about the appointment of the judges. A judge of the Supreme Court is appointed by the President. While appointing the Chief Justice of India, the President may consult such other judges of the Supreme Court and High Courts as he may deem necessary for the purpose. The Ministry of Law and Justice requests the outgoing Chief Justice of India to recommend the name for the successor. The outgoing Chief Justice of India suggests the name of senior-most judge of the Supreme Court. The Ministry of Law and Justice refers the name to the Prime Minister, and the Prime Minister advises the President accordingly. The other judges of the Supreme Court are appointed by the President in consultation with the Chief Justice of India. Now there is a question, and it is the advice of the CJI on the appointment of the judges binding on the President? It is being discussed by some examples. Like first is in the S.P. Gupta versus Union of India case 1982. Also known as the first judges transfer case, the Supreme Court held that the advice of Chief Justice of India is not binding on the President. In the second case, when in the Supreme Court Advocates on Record Association versus the Union of India case 1993. It is also known as the second judges transfer case. The Supreme Court held that the advice of Chief Justice of India is binding on the President. The court held that before giving advice to CJI, he has to consult two senior-most judges of the Supreme Court before advising the President. And that's how the collegium system evolved. In the Presidential Reference 1998, the Supreme Court held that the Chief Justice of India shall consult four senior-most judges of the Supreme Court. This consultation should be in writing, and the name agreed upon by the CJI and two other senior-most judges to be recommended to the President. The President can send back the name to the collegium for reconsideration only for once. Now let us discuss the next topic, which is the qualification of a judge. The very first qualification is citizen. He should be the citizen of India. Secondly, he must have been a judge in one or more high courts in succession for 5 years, or advocate in one or more high courts in succession for at least 10 years, or a distinguished jurist in the opinion of the President. Now let us discuss about the removal process of the judge. The process has been mentioned in article number 124, and the judge is removed by the President. After the passage of the resolution by both the houses of the Parliament, by a majority of total membership of House, and by a majority of not less than 2/3 of the members present and voting. And what is the ground? Proved misbehavior or incapacity. And it is mentioned in article number 124 clause 5. It authorizes that the Parliament to regulate by law the procedure of presentation of the resolution and for the investigation in proof of misbehavior or incapacity of a judge. Accordingly, the Parliament passed Judges Inquiry Act in 1968. Resolution in this regard can be introduced in either house of the Parliament. If the resolution is to be introduced in the Lok Sabha, it has to be signed by at least 100 members of the House at the time of its introduction. And in case the resolution is introduced in the Rajya Sabha, it has to be supported by at least 50 members of the House at the time of introduction. After the resolution is duly introduced, the presiding officer of the concerned House is to constitute a three-member committee. The Judicial Committee comprising of CJI or a judge of the Supreme Court, secondly, a Chief Justice of one of the High Court, and third, an eminent jurist who is an advocate who is very experienced. The committee shall frame the definite charges against the judge on the basis of which the investigation is proposed to be held. Such charges, along with statement of the grounds on which each charge is based, is to be communicated to the judge, and he is to be given reasonable opportunity of presenting written statement of defense within specified time frame. The judge, in case of allegation of misbehavior, is to be given reasonable opportunity of cross-examining of the witnesses and defend himself either personally or through an advocate of his choice. If the report of the committee contains a finding that the judge is guilty of any misbehavior or suffers from an incapacity, then only motion will be taken up for discussion and voting in the houses of the Parliament. The judges of High Courts and the CAG, the Chief Election Commissioner, and the State Commissioner can be removed in the same manner as the judge of the Supreme Court is removed. Now let us discuss about how the judges are appointed. The first is acting Chief Justice of India. It is mentioned in article number 126, and he is appointed by the President. The ground is vacancy in the office of the CJI. Second one is ad hoc judge. It is under the article 127. The Chief Justice of India with the prior consent of the President. And the ground is lack of quorum in the Supreme Court. Next is attendance of retired judges of the Supreme Court and the High Courts in the Supreme Court. It is mentioned under the article number 128. And then he is appointed by the Chief Justice of India with the prior consent of the President. Ground is excess work before the Supreme Court. In the appointment of ad hoc judge, the Chief Justice of concerned High Court is also to be consulted. An ad hoc judge shall have all the jurisdiction, powers and privileges and shall discharge the duty is of Supreme Court judge. A retired judge, while sitting and acting as a judge, of the Supreme Court shall be entitled to such allowances as the President may determine and shall have all the jurisdiction, powers and privileges of the Supreme Court judge. Now let us discuss about the jurisdiction of Supreme Court. The jurisdiction of Supreme Court have 5 bases: original, appellate, writ, revisory and the advisory. Now let us discuss every one by one. The first one is original. Is under Article 131, is federal in nature. The Supreme Court is the sole arbiter of the disputes that may arise between the center and the states and between the states themselves. Interstate river water disputes do not come under the original jurisdiction of Supreme Court. Original jurisdiction shall not extend to a dispute arising out of any treaty or agreement or other similar document which has been entered into or executed before the commencement of the Constitution, and it is operation even after the commencement of the Constitution. Now, the next is appellate. The Supreme Court is the highest court of the appeal in the country. All types of cases, civil, criminal, and as well as constitutional. The judges of High Court can be appealed. The judgment of the High Court can be appealed in the Supreme Court, but the Supreme Court is not bound to hear the appeal. Under certain circumstances, the Supreme Court is bound to hear the appeal. Now, what are the conditions under which the Supreme Court is bound to hear the appeal? First, if a matter is related with the interpretation of the Constitution. Second, if the High Court issued the certificate that the judgment can be challenged in the Supreme Court within a specified time. Third, if in a criminal case the lower court acquits a person but the High Court on appeal gives death sentence. In all other cases, one can appeal in the Supreme Court to special leave petition. It is mentioned under the article number 136(1). The Supreme Court may, in its discretion, grant special leave to appeal from any judgment or sentence or order in any case passed or made by any court or tribunal in the territory of India. Article number 136, clause 2 holds that the Supreme Court cannot grant the special leave petition against any judgment, order given by any court or tribunal relating to the armed forces. Next is writ jurisdiction. Article number 32. Under Article number 32, clause 2, for the enforcement of the fundamental rights. Article number 139 holds that the Parliament may by law confer the Supreme Court the power to issue writs for any purposes other than those mentioned in the Article number 32, clause 2. Next is the revisory jurisdiction. The Supreme Court has the power to revise its own judgments. Under the Article 137, the Supreme Court has the power to review any judgment pronounced or order made by it. Article number 144(1) holds that the law declared by the Supreme Court to be binding on all the courts within the territory of India. A binding decision or Supreme Court or High Court can be reviewed to review petition. A review petition can be filed by the aggrieved party who are not satisfied with the decision of the Supreme Court, as for rule number 196 of the Supreme Court. A petition is to be filed within 30 days of the pronouncement of the judgment or the order. If a review petition is dismissed by the Supreme Court, it can be considered as the curative petition. The Supreme Court evolved concept of curative petition in the Rupa Ashok Hura versus Ashok Hura case in 2002. In this case, it was held that so as to prevent the abuse of process as well as to cure miscarriage of the justice, the Supreme Court may reconsider its own judgment. There is no time limit for filing a curative petition, and it is guaranteed under Article number 137 of the Constitution. Next and the last one is advisory jurisdiction. The President can refer any case. Under Article number 143(1), the President can refer matter of law of fact of public importance to the Supreme Court for its opinion, and the Supreme Court may, after such hearing as it thinks fit, report to the President about its opinion. Now, let us understand the transfer of certain cases. Article number 139A. It was added by the 42nd Amendment Act. Article number 139A holds that where the cases involving the same or substantially same question of law pending before the Supreme Court, one or more high courts, or before more high courts, and the Supreme Court is satisfied that such questions are substantial questions of general importance, court may withdraw the case or the cases pending before the High Court or High Courts and dispose of all the cases itself. Article number 139A, Clause 2. The Supreme Court can transfer case pending in High Court to another High Court for the ends of justice. Next, we are having the High Court. The Constitution under Article number 214 provides for High Court for each state. Article number 231 authorizes the Parliament to establish a common High Court for two or more states or Union Territory. A judge of the High Court is appointed by the President in consultation with the Chief Justice of India. For all practical purposes, the President appoints the judges in the High Court with the recommendation of the Collegium consisting of Chief Justice of India, two senior-most judges of the Supreme Court, and the Chief Justice concerned High Court. A judge of High Court can be removed in the same manner and on the same grounds as a judge of Supreme Court is removed. The retirement age is 62 years. A person who has held office as a permanent judge of High Court not to plead in any court or before any authority in India except the Supreme Court and the other high courts. Transfer of a High Court judge under the Article number 222. Judge can be transferred from one High Court to the other High Court by the President on the recommendation of the Chief Justice of India. In the first judge's transfer case, Supreme Court held that a judge can be transferred even against his wishes. At least one-third of the judges must be from outside the state, and by convention, the Chief Justice of High Court is also from outside the state. Now let us discuss about the appointment of additional judge in the High Court. It is mentioned in Article number 224, Clause 1. They are appointed by the President in consultation with the Chief Justice of India. And it is on the ground of arrears of work or temporary increase in the business of the court. The qualification is they must be qualified to be appointed as the judge of the High Court. The term is for 2 years and which can be extended. Now let us discuss about the appointment of the acting judge in the High Court. It is mentioned in the Article number 224, Clause 2. It holds that when any judge of the High Court other than the Chief Justice is by the reason of absent or for any other reason is unable to perform duties of his office or is appointed to act temporarily as the Chief Justice, the President, in consultation with the Chief Justice of India, may appoint a duly qualified person act as the judge of the High Court until the permanent judge resumes his duty. Now let us discuss about the last topic for today, and that is supervisory jurisdiction of the High Court. It can be deducted from 3 articles of the Constitution: Article number 227, Article number 228, and the Article number 235. Now let us discuss each one of them one by one. The very first is Article number 227. Pre-High Courts has superintendence over all the courts and tribunals throughout the territories in relation through which it exercises its jurisdiction. Article number 228. A High Court can transfer certain cases pending in the subordinate court itself if it is satisfied that the case involves substantial question of law as to the interpretation of the Constitution. Article number 235, the control over district courts and the subordinate courts, including the posting and the promotion of any of and the grant of leave to the persons belonging to the judicial service of a state and holding any post inferior to the post of district judge is vested in the High Court. The appointment of persons for the post of district judge and posting and promotion of the district judge is made by the governor of the state in the consultation with the concerned High Court, and it is mentioned under Article number 233, Clause 1. Now let us know what is the court of record. It is a technical term. A court of record is that court which fulfills two conditions. Firstly, its judgment is of evidentially value throughout the territory of India. And the second one is it has the power to punish an individual for its contempt, where we can understand by this that the lower courts are not having the power to punish individual. So only the high courts or the Supreme Court can punish. So they are being declared as a court of record. It is also mentioned in the Constitution. It was on the basis of report of H.N. Sanyal Committee on Contempt of Court Law in 1963. The Parliament enacted the Contempt of Court Act 1971. There are two types of contempt, which is one is civil and the other one is criminal. Now with this, I am concluding my video today. Thank you.